everybody. Starting on the order that I see you in the Brady Bunch cubage. Miss Slate, can you hear me?
Good morning.
Can you say something? Good morning. Mr. Colvin.
Morning, Honor.
Okay, Mr. Henderson.
Good morning.
And you have the middle slot on my screen, so and Miss Henderson.
Good morning.
And Mr. Gutierrez. Michael, you need to unmute. That way I know I can hear from you. Thank you for all the fun and all the reading. Yes, I read both files.
Transcripts. I think
Yeah,
page
well, I went through both files.
39 and 40 are the best.
Yeah, I've got the note that I've got is I went to transcript 32 line 4 and 5, but then I realized you guys were both saying the same thing. Just yours was combined in number 2 and his was 2 and 3 in the order. So because I went through the orders to figure out T38 I've got marked, and yeah, T40. Yep, I've got all those marked. But yeah, I also read the rest of the file. Thank you. In any event, I try to be up to speed, especially if it's something the judge is working primarily on, not me. She's unavailable this week, so you got stuck with me. Sorry, guys. So we will go on the record in the matter of, wait, we lost Mr. Gutierrez. Oh, no, we didn't. No, he's there. Everybody switched around.
Sorry for the delay.
Yeah, okay. Yeah, no, that's okay. I looked down at the paperwork to look at where I'd marked the transcript pages, and then I guess all the blocks just rearranged. So forgive me. You weren't where you were when I looked down. Now we're here in the matter of Henderson versus Henderson, case number 20-02462DM. Anybody want to choose which issue we want to start with?
Yeah, if you want to start with the order, that's probably a good starting point, and then we can move on to the information.
Okay. From what I can read of the two orders, the only real difference between the two is number, I believe it's 4 on yours, Miss Slate, and 5 on yours, Mr. Colvin, correct? It's the subpoena issue concerning the counselor. All the other ones look like they matched up pretty well.
The hearing begins with a relaxed atmosphere, but that tone hides something important. The referee makes it clear almost immediately that preparation matters more than courtroom drama, mentioning the transcripts, comparing different drafts, and pointing to specific lines sends a message before any legal issue is even debated.
Number 3 was whether or not the notes would be provided to counsel.
Yeah, I think that was
the only change there. Number 7, I honestly think we're saying the same thing.
Yeah, I think you are too. I mean, there was some difference in wording, but I think you're saying the same thing.
Yes, Your Honor.
In essence, the one that I found the most difference in was number 4. And I realize I'm at a disadvantage here because while I had the transcript, I did not have the benefit of your meeting with the judge in chambers. So, which I always think is a weird word. I generally call it my office. The word comes from the fact that they used to meet in the person's bed chambers.
Oh,
that
really?
Was connected to, yeah. When you were dealing with royalty or the cardinals who did the courts of equity, or the king or his ministers who did the regular courts of law, they would meet in castles. So typically the audiences were performed in the chambers because that's where everybody met, because it was the warmest place in some of the times. So, all right. Anyway, now that history lesson. Okay, so we've got number A, which is all records already provided by the guardian ad litem. You guys are good with that. Information stating the frequency and attendance of counseling sessions. I kind of got the gist that was in there. Oh, I think I just switched whose orders whose. Can't do that. I had them one to my left, the other to my right. Because that was why I was able to follow along with whose order was whose, and I don't want to screw it up. Okay, I've got Allison, yours is on my left. Scroll, yours is on my right. Miss Slate, I don't think there are any indication there that you get records. I think the judge was very clear she did not want records released to the court. So I think that wording is inappropriate from what I read. And I'll note that in the transcript, she specifically
we're talking about the counselor's records.
Right. What I what I want to know is if he's working on the issue, is he actively participating? Is he doing the things that are being recommended? In other words, is he in compliance and adherence with medical?
Your Honor, I think
But prior to, I don't
spot
want
for that.
she.
Oh,
Yeah, I don't need to know the intimate thoughts that he shared with his counselor, which would be the records. I don't want them to become part of the public sphere. I just don't, because it's not necessary for me to know that if he then is still struggling and he relayed that to her. I went on for a period of time and he said, so I think you do get a notification from the counselor outside the scope of client-patient privilege that he has relapsed, because that may be
Your
the
Honor, and
only
that
way
was
of
the
knowing,
main dispute.
but not the
Because
record.
I
I think
won't
you,
know.
yeah, but I don't think you get the record. I think you get a notification. And that would
And that
follow
would be
in whether
fine
he's,
if they want to
and,
create
and
an email to me, just like the GAL.
right. And that might be the way to do it if the counselor is available, because again, she did not want the intimate record. She didn't want the actual, I think you just need notification that he relapsed and that he's working.
Well,
I don't know.
Yes,
I
and
don't
what the
know if Mr. Colvin,
recommendations
yours is
are, what the plan is.
right. Yeah. And I don't know, Mr. Colvin, if yours is strong enough to say, is he generally following the recommendations? I think you need notifications that he is adhering and complying, and those are two different things.
okay, I can update that, but I think, Your Honor, it's my understanding, the judge made it very clear that ongoing, this was not something that a counselor ongoing. If Mr. Henderson was in counseling and said, "Yeah, I had a," now this didn't happen. This is a hypothetical.
I know. I do. Yeah.
But if he said,
We're
"Yeah, I
dealing
had a
with
really bad day," and I went and drank a few beers, and he tells his counselors 3 months from now, that counselor's not under an obligation to then email Miss Slight and say, "Oh, hey, just so you know, Mr. Henderson admitted to me that he did this or that." That is the actual intimate details of the counseling that she was referring
No,
to and did
that
not want to
she
see.
can notify the counselor that he did relapse. That's not any
Yes.
intimate detail. That is, he relapsed. It's one
And I
thing for
don't
him
need
to
to know
say,
why.
and
I don't need to know if it was.
here's where her thing said, I don't need to know the intimate details.
Both sides instantly understand that vague arguments are unlikely to survive because every claim can be checked against the written record. That changes the balance of power. Lawyers who rely on assumptions lose leverage, while attorneys who can connect every position to a documented statement gain credibility.
But
Right.
I need to know that he's in compliance. A relapse would be non-compliance.
No,
So that
I
would fall
think, Your
under
Honor, what
well, it would be okay. It would not be non-compliance. It would be non-adherence.
well, but adherence to the counselor's plan means
Right.
going to counseling, working through
Right.
your issues. It doesn't mean adherence to a no drinking order from the court. She's not saying the counselor is responsible for enforcing a court order and notifying of relapse. Adherence to what the counselor is recommending as far as
But I don't
time,
think anyone has argued he
attendance.
doesn't have a substance abuse problem.
Attorney
Right.
Slate, I can't even finish my sentence here.
Okay, let him finish. Yes.
So adherence to what the counselor's recommendations are as far as timing, attendance, specificity of how we attend this counseling, not adherence to the court orders. What this would do if we entered that order forevermore, as long as he's seeing this counselor, he now, if he discloses something, that's going to opposing counsel, whether we have a motion pending or not.
No, the only thing that's going to be disclosed is if he actually drinks.
Okay, but I'm going
Or
to tell my
uses.
client, if you drink, please do not tell your counselor, which means counseling is now irrelevant, right? I mean, you can't work through a substance issue if there is one, if you
And
can't
if
talk
that
to your
and if
counselor.
and if that happens, his parenting time will continue to be problematic and suspended. The idea here is the rule of thumb is that we want at least 6 months of complete sobriety, and we need to know that that's happened. And that rule comes from Child Protective Services cases. It's not in any
Which
law.
right,
It
I
is
agree
normally
with,
if there is 6 months of sobriety, then
I agree with,
typically there's a good indication and good indicia that he is doing better. And if the counselor is
absolutely.
the only place that we're going to know about that from, because I realize the judge bifurcated it. Well, she bifurcated it in the fact that the children were not present during his relapses. Personally, in reality, that doesn't matter. A relapse is a relapse because that's just when you get caught. Now, the problem with that is It doesn't matter whether he's with the kids or not. If he's using, he's using. And that's problematic because then do we really know if he's using with the children or not? There are many functional alcoholics and many functional drug users. Just because they're functional does not mean they're not problematic. CPS and I went back and forth on me returning children to a functional cocaine addict. And she was functional. The kids were not neglected. They were not abused. They were well cared for. 3 of her older kids had been in college, but she was a functional cocaine addict. I know that doesn't sound, I'm from the 70s and 80s. You know, there are a lot of people back then. But in any event, yeah, you know, I think that he needs to be honest, and I think that he needs to be honest for his children, because the court needs to know if he's relapsed, and that he's reintegrating with the fact that he's complying with the treatment plan and adhering to it. He's not adhering to court orders. I'm asking him to adhere to the treatment plan and compliance with the treatment plan. And if he falls off the wagon, that's non-compliance. And you know, yes.
If I may, but right now, two notes. I mean, I understand, and he is sober, and this is the tough
right,
thing.
which is great, because then there's nothing to report.
Right, exactly. But I also want to be careful though, because what we're saying is right now the court, if this was your order, is dictating what that treatment plan is. Right? You're saying
No,
if
I'm
he
not.
relapses.
No, I'm not. I'm asking for, because that's, if he relapses, that's non-compliance with a treatment plan, and that's what we want.
But how? What is the treatment plan then? We would need the
treatment plan is to keep him as sober as possible, and to know whether he's going to be a danger to these children or not.
But is that the counselor's treatment plan? That's what I'm stating.
Yeah.
It
well,
sounds like
it's the counselor's treatment plan, but if the counselor notices that he is relapsed, then the court should be notified. I mean, that's non-compliance because he's relapsed. Now, I know that's a nuance, but it's also the only thing we've got.
I think I'm struggling with the fact that.
But I don't want. I don't want. There will be no records turned over. I don't want to. I don't care how he relapses. The guy's got a monkey on his back, and it's not easy to comply with.
The discussion quickly shifts from simple wording to the much larger issue of privacy versus accountability. At first glance, the dispute looks like editing an order, but the real conflict is deciding how much information the court actually needs to protect children.
You know, as it was explained to me long ago when I was in biochemistry, and then I worked on a lockdown psych unit for a while with substance abusers. Typically, alcohol is easier to process than any kind of fructose or sucrose or ADP at all in the cells. Once the mitochondria, the engine of the cell, learns to use alcohol as a fuel, it demands it because it's easier to convert to energy. As such, every cell in your body, once you've got to a certain level, demands the alcohol, thus the cravings, thus the withdrawals, thus the problems. So the longer that he's been drinking, the more his cells have become used to it. As such, I expect somebody to relapse every once in a while. But the relapse also causes a spin cycle of now the cells have the alcohol back and they're going to start craving it again desperately because it's easier to work. So we are stuck with a large problem here. The court is trying to determine that he is safe. If he would like to self-report that he's relapsed, that would be wonderful. But how are we going to prove it?
Yeah, right.
What I'm saying is,
I think it's important though.
Yeah. I mean, it's an important nuance.
It is, and I think the judge made it very clear that he is not waiving his
he's not waiving his privilege.
So, right. So if we require ongoing, forevermore, if he talks to his counselor and mentions drinking, the counselor now reports that is a waiver of privilege that the judge did not order.
All right. Violation of a court order would be a contempt charge, correct?
Yes, Judge.
If a counselor was counseling someone on the fact that they are a kleptomaniac, is it privileged information for the patient to tell the counselor, yeah, I stole $100,000 yesterday? No, because it's a crime, and that's outside the scope of privilege, just as it would be for an attorney.
No, it's a past.
I'm equating it to you're in violation of a court order, which in your case is the law in your case. You would be in violation of it.
Understood, Your Honor. But if that's reported to a doctor or a counselor, attorney after the fact, it's not a privilege. It's still privilege because it's not an ongoing crime that they would prevent. I mean, again, I don't want to.
All right.
I guess my
Well,
argument would be
but at
that I
some
don't
point-
believe that's what the judge ordered.
All
But
right.
if that's your interpretation, I do understand.
As long, I'll tell you this, as long as it's under the definition of compliance, then she is ordered to tell us whether he's complying or not. She doesn't have to tell us when. She just has to tell us he's in full compliance, and that includes, she doesn't even have to say, I'll tell you this, I'll let it go at this. She doesn't have to tell us that he relapsed. She just has to tell us he's not in non-compliance. And for the court's ruling, the non-compliance would include that he relapsed. So in other words, it's kind of like pleading the fifth. Yeah, I plead the fifth. In civil cases, the court can hold that against you and presume you did it. So if he's in compliance, we can presume, Miss Slate, that he's not relapsed. How's that definition? If he's in non-compliance, the presumption is we got a problem and you got to keep going to counseling and nothing's changing. Would that help, Mr. Colvin? Then there's no admissions. There's no saying what happened or why. But that opens the door to not the simple act of relapse. That opens the door to any non-compliance or non-adherence. In other words, you miss AA, you're in non-compliance. We won't know why you're in non-compliance. You're just in because it does. She did say she wanted to know whether he was complying or not, right?
Complying with the counselor, yes.
Right. And if he's complying with the counselor, that means he goes to every AA, he goes to every NA class. If he misses one of those, she's going to notify the court that he's in non-compliance. Now we don't know why. It could be a non-compliance to a I'm trying to be clear. A non-compliance to attendance of AA is still non-compliance, but if you're not going to tell me what the non-compliance is, the court can make the worst presumption.
I understand, referee. When you're using that as an example, right? Because right now the counselor hasn't said he's got to go.
Yeah, I'm using that as an example because I don't know what the treatment plan is.
Okay, good. I just wanted to be clear for the record. We're not saying
right. I'm just saying if you want to make if you want to make it generic, it's going to be generic, and that could have consequences the other way. I was trying to narrow the scope so that I was hoping that there would never be a notification.
The conversation becomes increasingly focused on definitions, because definitions ultimately decide outcomes. The debate over relapse, compliance, and adherence is not about vocabulary. Each word carries legal consequences that could affect future parenting decisions.
But if you want it to be, to do it the other way, now you've got a broad definition because the judge did order the counselor to tell us whether he's in compliance or not. So I don't know how detailed that plan is, but now if you add that to, compliance, whether he's relapsed or not, all she has to tell us is that, I'm sorry, but he's in non-compliance. Thank you. So I would order that as the generic term then. That gives you what you want. You don't have to be specific, but it also says that if he's in non-compliance, we don't care why, he's just in non-compliance. Because personally, I'd let somebody off the hook for non-attendance at an AA, especially if they got into a car accident or something. But we won't know that because we won't be specific enough.
Okay, so just do you mind if I read
exactly what I would?
Well, I think that's what the judge ordered. So
okay, yeah.
So if I put in the order, just so we don't have another, back and forth and all that. If I put in the order that must report, the counselor must report to the court if Mr. Henderson is no longer in compliance with the treatment plan.
With the treatment plan, and that includes whether he's relapsed, but she does not have to explain why he's not in compliance. So I don't know if his relapse would be part of the treatment plan or not, because I haven't seen the treatment plan. I would assume staying sober is part of any treatment plan. It was part of any treatment plan I would notice as a substance abuse treatment plan. But I dealt mostly with the schizophrenics, not the substance abusers. And the depressives.
So does the court just want to correct that paragraph? I could send over the Word document and then the court can just enter it so we don't have the same problem.
That would be fine. But records, there are no records that will be turned over. She does not, and that was very expressive of her. She wants no records. She just wants whether he's been in compliance or not, and that compliance would include, any faltering on the plan, including a relapse. So we won't know when, we won't know why, we won't know what. All she's going to notify us is that he's in non-compliance. I think everything else was okay on that order, right? And now I'm going to apologize to Mr. Gutierrez. I think I wanted to start with his so that we could that way we could release him, but now he got to listen to all the fun. So,
are you saying
you'll pass it by Mr. Colvin, Miss Slate, correct?
Yes.
You're not going to just send it to the court. Make sure he gets a copy. That
Well,
way
no,
you can add it.
I'll just send my, do you want me to send my original and the court can modify the language to what exactly the court would like it to be?
No, because I want you two to agree to it. Because Mr. Colvin has some
Okay.
legitimate
All right.
concerns, and I understand them. So I was trying to take into
Okay.
account all those concerns. All right.
I do think there's another difference, Referee Kometz, on it would
Yeah.
be number 6 regarding the, well, I guess this kind of is part of the other issue, but it's the subpoena for communications to his previous employer. I don't know.
I think
if
we're
it's
about to deal. I
sorry.
think that aren't we about to deal with that with the subpoena and the
It's a
orders on
different
this?
subpoena, but it's either to his Mark Henderson or to the employer directly. I think they were 2 different subpoenas. I don't know if it's a difference that you take issue with, but it's whether or not all emails and communication or emails and communication with respect to termination or end of employment.
I think she said termination and end of employment, and anything in the first personnel file that would back that up, because normally before you terminate somebody, there's a couple of write-ups. I would hope that they did that. I realize it's a family-owned business.
Right. And
but anything relating to the termination or discipline that led to the termination. I generally warn people that will hold the job against you if you were drinking and you lost the job because of alcoholism, because that's your fault.
Well, that's not
the referee recognizes that every extra sentence added to the order may create obligations that were never intended. Instead of accepting broad language, the discussion keeps narrowing toward objective reporting standards. This is how experienced courts avoid future disputes. Ambiguous language creates litigation, while carefully defined responsibilities reduce opportunities for competing interpretations months later. The final portion of this segment reveals the referee's broader judicial philosophy. Rather than treating addiction as a simple question of personal choice, the discussion acknowledges its biological and practical realities without excusing accountability. That perspective shapes every proposed solution. The goal is not to punish relapse automatically, but to ensure the court receives reliable information when safety could be affected. At the same time, the referee refuses to undermine the therapeutic relationship by exposing confidential conversations unnecessarily. The compromise gradually shifts toward reporting overall compliance instead of specific admissions, attempting to satisfy both child protection concerns and privilege rights. Even as the hearing begins moving toward subpoena issues involving employment records, the underlying pattern remains consistent. Every ruling is being tested against one standard, whether it creates a fair process that protects children without expanding court authority beyond what is genuinely necessary.